I understand with the murder case, the way it's charged, which is legally a way it can be charged, because you were evading, you actually didn't hit the person in the crosswalk. The police actually hit that person chasing you, right? And so when you're sitting at the prison, you're probably going to start thinking, I shouldn't be here. Other people are going to start talking to you saying, you should have done this and that. But what I can tell you, that's the law, right? Things, those are called their conditions. And they're just like, well, I know I didn't do anything on probation, but I didn't pick up any new offenses. I'm just out here living my life. If that's the case, then you're not really on probation because you're not reporting, you're not doing anything that you're supposed to do. You're just living your life. And when people come before me and they say, I know I haven't reported for over a year, which you haven't reported for over a year, but I didn't pick up any new cases. Do you know that is not really saying anything? Because there are a lot of people who are not on probation and who haven't picked up any new cases. That's like the bare minimum. Don't pick up any new cases.
Now, let's see how Judge Boyd handled different criminal offenses. Starting with Camaro, who was already facing felony weapon charges when he fled from the police, only for the chase to end in the worst way. Let's see how the judge handles this.
All right, the court is calling 2024 CR 5218 and 2024 CR 5219, State versus Renee Camarillo. Can I have parties announced?
Jason Gary here for the state.
Marissa Giovanco from Mr.
And are you Mr. Camarillo? All right, you entered pleas in each of these cases on June 10th, 2025. Are both parties ready to proceed with sentencing?
Yes, sir.
Yes, Judge.
All right. And 2024 CR 5219, you entered a plea of no contest to count 1 and count 2. The court found that there was evidence to find you guilty of count 1 and count 2. The court found you guilty of count 1 and count 2. According to your plea bargain agreement, counts 1 and counts 2 will run concurrently, and you will be sentenced to 20 years in the prison. Give you credit for any time served. This is the run concurrent with 2024 CR 5218. Take in consideration 2025 CC 005805. Is there anything else with regards to sentencing and that cause number?
Send it to you, Mr.
Okay.
Okay. And just one moment. Also, there is to be no contact with the following persons: Sarah, SaarahAmin is the last name. Tariq, Tarek, last name Ramadan. All right, and that cause number, did you review the document entitled Trial Court Certification? I'm sorry, one other thing. With regards to sentencing, there's an affirmative finding of deadly weapon in count 1 and an affirmative finding of a deadly weapon in count 2. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Do you have any type of drug issues? Okay. And then in cause number 2024 CR 5218, you entered a plea of no contest to count 1, murder. The court found that there was sufficient evidence to find you guilty, and the court found you guilty. The court will sentence you to 20 years in the prison, give you credit for any time served. This is run concurrent with 2024 CR 5219. And taking consideration 2025 CC 005805. And there's an affirmative finding of deadly weapon. See. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? You need to speak up. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you? All right, you're 18.
Too bad. He just rewrote his life completely, all because of one careless decision.
Any time that somebody serves is a lot of time. Many things can happen at the prison. Do not become institutionalized at the prison. You need to realize that you're where you are now because of your actions. I understand with the murder case, the way it's charged, which is legally a way it can be charged, because you were evading, you actually didn't hit the person in the crosswalk. The police actually hit that person chasing you, right? And so when you're sitting at the prison, you're probably going to start thinking, I shouldn't be here. Other people are going to start talking to you saying, you should have done this and that. But what I can tell you, that's the law, right? So at the prison, you can still get your education. At the prison, you can get some kind of trade so that when you're released from prison, you have some ability to get work. And it's going to be hard for you to find employment because you've been to prison. That's why you need to learn a trade at the prison. I don't know if they still do welding at the prison or not. I had one client who went to prison. He ended up becoming a welder. And there was such a high demand for welders, even though he had been to prison. When he was released, he ended up making more money than I made as an attorney. All right. So there's something you can do with your life, but you need to start thinking about the people you hang around with, and how you find yourself to be in the situation that you're in. You understand? So there are two people who are going to be speaking to you, and this is called a victim impact. So they're going to tell you probably how this has impacted their life. I want you to listen and internalize what they're saying. Okay. All right. Watson and Simmons. Let me see if we can get them. Would you call them, please? Because they're in the, here they are.
Yeah, I'm here.
All right, you can show your video if you want to show your video, but you don't have to show your video. Are you able to see Mr. Camarillo?
Yes.
All right. If you want to show your video, you can. If you do not, you don't have to. And you can begin whenever you're ready to begin.
Okay. So my name is, I am the eldest daughter of India Watson. She was one of the victims. She was the victim that actually lost her life, a pedestrian crossing the street. My mom was only 47 years old, with 3 kids under the age of 30 and 12 grandchildren at the time. When I received a call of her death, I was 34 weeks pregnant and my sister was about 26 weeks pregnant. She never had an opportunity to meet those babies. She would never get to see her grandchildren graduate from college. She would never be able to attend my siblings' weddings when those times happen in the future. This has been extremely traumatizing on our family to not only lose her so suddenly, but in the manner she was killed. Some of the family had to witness video footage of the accident. Law enforcement was going so fast on the night she was killed that my mom was hit at a fast rate where her body flew into the air before it landed on the ground. At the funeral, her face had to be reconstructed for us to have an open casket. She had to be fully clothed with gloves. Ears cannot be shown. The woman who raised me, that I knew to be my mom, I didn't see that woman physically. She was unrecognizable. While I understand you were not driving a vehicle that collided with my mom, you have a role. The actions you played and the things that you did throughout the day contributed greatly to her death. It is difficult to accept that one day you will walk free and have the opportunity to make new memories with your loved ones. Meanwhile, we are left to pick up the pieces of a family torn apart. There is no sentence that can restore what we've lost. We live with the consequences of your actions every single day. The leniency of your plea deal does not reflect the magnitude of the harm you caused. My hope is that you will use the time not just to serve a sentence, but to reflect and grow into someone who values life and considers the pain and reckless choices that you can put on others. Thank you, Your Honor.
Thank you so much. I'm sorry for your loss.
Thank you.
Ms. Simmons,
Yes, Your Honor. Good morning.
good morning. You may proceed.
Thank you. Thank you for the opportunity. I am the maternal sister of Andrea Watson, and she was the youngest of my mother's 6 children. We certainly did not expect to bury our baby sister at the tender age of 47. There are 5 of us remaining. Andrea had a very large extended family, and she was loved and her life was valued. So it's a great loss to our family. And certainly, as my niece just explained, she had 3 young adult children and now 14 grandchildren. So we have a lot that she left us. But at the same time, those children will not have a grandmother that they can share memories with going forward. This was an unnecessary occurrence. It was an accident, but unnecessary. And I do hope that going forward, this is something that you will think about as you'll have time to visit in prison and think about the impact that you had on a lot of people in our family, certainly. I was very intimately involved in her funeral proceedings. So it was extremely difficult for me. Had a lot of emotional and psychological impact, of which I'm in therapy for. And I encourage all of my family to do the same, because we have been in great pain for over a year now, and we're still suffering from the loss of our loved one. So it continues to be a difficult situation. The wounds are reopened each time I revisit the details surrounding her death, and there have been many instances since the funeral that we've had to go through writing statements and other things to try to clarify and close out what has happened here. So, with all that being said, I just pray that justice will be served, and that at some point there will be some light that comes out of this dark, dark space that we were thrust into with the loss of my sister. Thank you, Your Honor.
Thank you so very much. And I hope you realize the impact, the negative impact you've had on other people's lives. Because do you have somebody in your family that you love a lot? Who would that be? All right. Can you imagine what if it was your grandmother just minding their business, obeying the law, walking in a pedestrian, and there is somebody out there driving recklessly, evading the police, knowing that they're in the wrong, and your grandmother got hit? So you need to understand their pain. You understand? All right. Good luck to you. You're welcome. Thank you both for coming in, and you are excused. The advocate will speak to you.
Well, here is Miss Marvitt, who assaulted her boyfriend grandmother and still went on to violate the protective order by sneaking back into the home. Crazy, right? Let's see how the judge handles this.
Can I have parties announced, please?
Representative for the state of Texas.
Denny Callahan, defense.
And are you Vanessa Miravete?
Yes, ma'am.
All right. You entered a plea to injury to the elderly. According to your plea bargain agreement, the state is silent on your application. And there's an affirmative finding of family violence, and this is run concurrent with a county court cause number. All right. Are there any witnesses? Defense?
No, Your Honor.
All right. The court will hear your argument.
Your Honor, asked the court to take notice of the jail classification. Its weakness, of course, is that it's self-reported, but it corroborates to some degree what the MEC evaluation says. In the past, she's had mental illness problems, and less so now. And the number 2 point, Your Honor, is that the complainant in this case, in both cases, misdemeanor, your court, not interested in hurting this woman. She filed on prosecution, but there was a damage made by glass broken up against her eyes, so there was damage. She's remorseful for that. Her plan is to live with a 35-year-old friend of hers that she's known for a couple of years. There's no more contact between the boyfriend and the complainant, who is the boyfriend's grandmother. That's finished. That's over. And she doesn't plan to return to that. I asked the court to consider deferred adjudication with some type of supervision regarding where she's going to live. Nothing further, Your Honor.
All right. So let me understand this. So the facts of this case are that the elderly person was in an argument with her grandson. Is that correct?
No, Your Honor. The other way.
It says,
grandmother
it said
with
she had been arguing with her grandson and the suspect got involved.
Oh, prior to that, yes, Your Honor. But the real issue was conflict between grandma and her.
All right. You want to raise your right hand? Do you solemnly Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. State your name for the record.
Vanessa, Miravete.
All right. I'm having trouble hearing you.
Louder.
Vanessa Miravete.
All right. So what is your relationship to the victim in this case?
There's no relationship anymore, but I was with her grandson,
All right. So and how old are you?
24.
24. And how old is the grandson?
He just turned 20 in January.
All right. And you were living with her?
I was living there for about 5 or 6 years
You were living with her.
with her and the grandson.
All right. But that's her house, right?
Yeah.
It's not the grandson's house. So you come in and you live with the grandmother and the grandson.
Yeah.
And then she gets into an argument with her grandson.
Mhm.
And what was that argument about?
I don't remember the exact details due to the fact that
I'm sorry, I can't hear you.
I don't remember the exact details because I was under the influence.
Under the influence of what?
Xanax.
All right.
Talking to my ex.
So she's in an argument with her grandson, and then what do?
Um, so I was, I guess, like in the middle, I guess. There was a lot of things going on due to like a lot of abuse.
You have said some things, but you haven't told me anything. So,
Yeah, Your Honor, how
Yeah.
did she get hurt?
So I got pushed into her.
no,
by the guard.
that's not what this says. Because if you were just pushed into her, then maybe you need a jury trial. If you're saying you were just pushed into her. But that's not what it says. In the police report, it says, while on patrol in a marked vehicle, I was dispatched to the listed location for an assault in progress. The caller stated his brother and the girlfriend were arguing, and the girlfriend hit the grandmother. The caller stated the grandmother was bleeding from her head and nose. I arrived to the listed location and saw both victim 1 and O1 sitting outside on the porch. Victim 1 had visible injuries on her face and head. Victim had a small cut on the bridge of her nose, which was still bleeding. Victim had a small cut on the top of her head that was covered in blood. Victim also had a lump on the right side of her head. Victim said she had been arguing with her grandson. Victim said she had been arguing with her grandson, and the suspect got involved and began to argue with her. Victim said she doesn't remember how or what she was hit with, but the suspect walked up to her and hit her. O1 said suspect had threatened to beat up the victim before. So unless you were on Xanax all the time you were at that house?
I was on Xanax for the last 2 years that I was living there.
Mhm. All right. Is there anything else?
Moment, please, Your Honor. Nothing further, Your Honor.
So why were you not living with your parents?
So, and,
Sorry, I cannot hear you.
so I'm from Wisconsin and like 5.
You're from the what?
From Wisconsin.
Okay.
And so I moved in with him and I was living with him basically for both of them because
Did you have a job?
no,
How long have you been unemployed?
since I got with her grandson
And how long has that been?
about 6 years ago, 5.
So 6 years you have been unemployed. So why did you leave Wisconsin to hook your life to this person?
It's just being young and
Because your parents said they didn't like him or something, and you decided to do it anyway?
no, I just my parents was approved, but at the time
And how old were you when you met him?
so I met when I was 17, but I didn't start a relationship with him until I was 18.
Mhm.
Like about a week after I turned 18.
And how far did you go in school?
9th grade.
Ninth grade? Yeah. So it sounds to me like you were not listening to your parents. Did your parents want you to get your degree or no?
They did, so I was taking care of my mom. My mom is disabled, and so I was taking care of her, working at the time, and I had a part-time job going to school. And I was taking care of my mom, which she's disabled, and my little brother who's also with autism. So I felt like I had a lot on my plate, and so I chose to work instead of go to school.
And then you chose to leave them on their own because you wanted your own life.
Well, my mom had got married and so she met her husband, which he still takes care of.
Mhm. All right. What is her criminal history?
No, don't believe. A lot of them.
No felonies, Your Honor.
So the only history she has are just the two cases that have been before Your Honor, which is this injured elderly and then the concurrent misdemeanor.
Violation of protective order? And is that with the same person?
Yes,
Yes,
with the same person, yes, Your Honor.
And when did that occur?
That occurred about a month after this took place.
So she had
Your
a,
Honor, brief summary of those facts if you'd like.
well, what date was the violation of protective order, the offense date?
December 17, 2024. This happened November 27th.
All right. So you want to tell me about this violation of protective order?
So I never like been in trouble before, so I didn't, realize like whenever, I didn't know how the law worked basically.
Well, I mean, if somebody tells you, if you receive an order saying that you can't contact somebody, that's how the law works. The order says you can't contact them.
Yeah.
So continue.
So I had went to pack my stuff, and so I was getting ready to leave, and I guess the grandson had got mad. That I was getting ready to leave because I was wanting to leave him too. I was with him for 6 years, on and off abusive relationship, so because I didn't really have family here in San Antonio, it was harder for me to like just walk away from a relationship.
All right. And what is this case about? The violation of protective order?
So essentially, the same victim in this injured elderly case had concerns that there were other people in the house that doesn't live. So she calls 911, police respond, she lets them into the house and they find this defendant hiding in the closet of her boyfriend's room. And she's removed from the.
All right. So obviously you knew there was a protective order because otherwise you wouldn't be hiding in the closet.
Well, I was forced into the closet. The grandson had threatened me into going into the closet.
The story you're telling me makes absolutely no sense. You have a protective order that you're not supposed to be there. You go there anyway. And now you're saying that you were hiding in the closet because the boyfriend told you to hide in the closet.
Well, he was very abusive. He had weapons and things like that, so I was very afraid of him. My family could testify to the abuse as well. They had called the police on him multiple times before all this occurred.
And when they called the police on him before, what did you do? Did you do an affidavit of non-prosecution or say, my family is not telling the truth?
So they never gave me like the option or like explain that to me how the affidavits work or anything.
No, I mean,
like
it's either you said yes or no, because times have changed. When the police are called out for an abusive situation, your attorney will tell you somebody's getting arrested.
Yeah, so
Now, after the
he would
fact,
get arrested and his sister would bail him out within like a few hours. So he would be home immediately after being arrested. So even when he had a protective order, the first time he got arrested, he was still back and he was still
because the protective order, that the house you were staying in, that's not your house. That's his grandmother's house. You all are adults just decided to impose yourself on his grandmother. You're there, you don't have a job, and you're just living off the grandmother.
No,
And
I
now,
have income, still from my family.
no, you told me that you hadn't worked in 5 years or 6 years.
Yeah, so due to the relationship, I wasn't able to work and I also didn't have like my birth certificate for a long time, so I had to get it sent out.
Here's the thing. I don't even know if you understand what you're saying to me. You keep changing your story. You told me you didn't have employment, that you hadn't worked for 5 to 6 years. And then now you're telling me, no, I wasn't just living off the grandmother. I had my own money. No, you didn't. You hadn't been working. I mean, you're saying, but you're telling me completely different stories. And
Well,
now you're telling me that you have a 35-year-old that you're going to live with. Who is this 35-year-old?
It's a friend of mine.
Who?
I don't know how to explain it. It's a friend of mine.
What's the name?
Jennifer
Jennifer what?
Ramos.
And where did you meet her?
So me and her know each other through mutual friends, and then we met, I don't know, I guess like in the neighborhood and stuff.
I'm sorry, met what?
In the neighborhood, I guess, or
So you're just meeting people in the neighborhood and now you're going to live with them? Does she have any children? What are their ages?
23, she has a 23-year-old, a 15-year-old. And then she has one that I think is like 10 years old.
All right. So if I give you probation, I'm not allowing you to live in homes that have children in them. So, and do you know who all lives in that home other than her and the children?
No, it's just them.
Hmm?
It's just them.
Are you sure? Have you been to the house? Do you know she has a boyfriend?
She doesn't have a boyfriend.
All right. So when have you been to the house?
So I was there once. I don't remember exactly when, like I said, I was like,
Was that before or after the violation of protective order?
that was before.
All right. Counsel, I don't know if she would be a good candidate for probation. I really don't know.
The remedy of sending to prison is a far worse remedy than trying to find a place for her to live, Your Honor.
Well, I know the state is asking for the minimum. And she applied for deferred adjudication.
He suggests going back to family in Wisconsin.
What I can tell you is you've applied for deferred adjudication. The state, according to the plea bargain agreement, they're asking that if I find you guilty, that your punishment be sentenced to 2 years in the prison. That's the minimum. If I grant your application for deferred adjudication and you're unsuccessful, you're looking at 10 years in the prison, potentially. Do you understand? So I can grant your application for deferred adjudication, or I can sentence you to 2 years in the prison. And the conditions that you receive are the conditions that you receive from me. There's no need to argue about the conditions that I'm going to set for you if I grant your application. So do you want the minimum 2 years in prison, or do you want to be on deferred adjudication with the court's conditions? Are you sure? Because let me just tell you, you know yourself better than your attorney knows you, better than I know you. I know that you've been dishonest with me today, but your choices are, and you need to think long and hard about it. 2 years is the minimum. The range of punishment for this offense is anywhere from 2 to 10 years in prison. If I grant you deferred adjudication, if for some reason your deferred adjudication is revoked, you're looking at potentially 10 years in the prison and up to a $10,000 fine. So you know whether or not you can complete this successfully or not. Part of being on probation is you are not allowed to use drugs, period. There's no marijuana, there's no Xanax, none of that. And I'm not going to allow you to reside in any home with children. You're an adult. You need to get your own place. You need to stop depending on other people. Do you understand? So, do you want the 2 years in the prison, or do you want deferred adjudication? All right. Yes.
6 years with no job or direction, and the best she could do is to turn violent and still give excuses? No, seriously, at 18 you should know better. I just hope she doesn't violate her probation this time.
Yes. All right. This is what the court will do. The court is going to sentence you to 8 years deferred adjudication. There's a $1,500 fine. Time and money will run concurrently. Oh, I'm sorry, state. Oh, you're right. Thank you. State your excuse. I appreciate that. So there's a $1,500 fine probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing with minors or anyone over the age of 55. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of family violence. There's to be no contact with Carmen Rivas or Hector Rivas. This is to run concurrent with 2025 CC 003873. Can I see the MIC evaluation again, please? Thank you. Thank you. In custody, the following: a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow all TAP recommendations. There's to be 200 hours of community service restitution. 100 of those hours will be deemed satisfied. You're going to obtain your GED. Do you understand? And the other 100 hours will be deemed satisfied if she obtains some type of trade school certificate or higher level of education. Do you have any children?
No.
All right. And you're saying you're thinking about a transfer to Wisconsin?
Yes.
Which county?
I'm not sure the exact county, but it's in Milwaukee.
All right. Let me see what Google tells us. No, they're saying it's Milwaukee County. So transfer to Milwaukee County. Field visits 1 time per month until further notice, and 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, yes.
Judge, can you repeat the sober support meetings?
90,
Okay, and anger management, possibly?
yes. I'll add anger management. All right, we can go off the record. Here's the thing, before you get in another relationship with anyone else, you need to get your life together and decide who you are and what you want to do in this world. You understand? She's in her world. Maybe probation will help her. Good luck.
Thank you, Judge.
You're welcome.
So, this time, we have Mr. Beltran, accused of aggravated robbery, but instead of facing charges, he is claiming rights. Let's see how the judge shuts him down.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue, that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? Mm-hmm. All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? Do you have any questions about the court's ruling?
No, Your Honor.
All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like, for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know. I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third party benefit in violation of the 7th Amendment. All right. Do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right. State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mm-hmm. All right. So the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331. Light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing into prosecuting me,
Mm-hmm.
which is they're the form a third party,
Okay,
and I'm not, I don't, third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that, I mean, how can I cross-examine the state of Texas? How can I,
so let me
Um,
explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything,
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls. Okay?
understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard right. It deals with ineffective assistance of counsel.
Mhm.
Right, Mr. Beltran, that's not to be heard right now?
All
Okay.
right. And let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the will for appointments, right? And if this is a first degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the will for first degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice,
Mhm.
and that addresses antitrust violations, brought upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right. So with that, I can tell you the state bar of Texas is not prosecuting you. The state bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right. So they're not going to be trying you.
Yes, sir.
All right. The next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right. So do you want that heard or no? All right. And then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right. State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this law.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right. Does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is the gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
All right. All right. Is there any other motion that needs to be heard?
Anything else?
No, ma'am.
Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right. Is there anything that you don't understand about the jury trial process? All right. So I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right. So if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right. So, counsel, you're still requesting a jury trial? All right. Norma, if you can put them on the jury trial, please. And Ms. Galloway, if you confer with the defense on a jury trial date. So they're going to get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
And now, this one is on Mr. Rodriguez, who was on probation for injuring a disabled person, then got caught with drugs. Let's see how the judge handles this.
Speak to an attorney. Do you understand? All right, we'll move on to 2024 CR 2941. Are you the same Edward Rodriguez who's placed on deferred adjudication in 2024 CR 2941 for the offense of injury to a disabled person with intent bodily injury on May 2nd, 2024 for a period of 6 years? All right, and did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney and understand it? All right, state.
Violation of condition number 1 on or about the 21st day of November 2024 in Bear County, Texas. The defendant, Edward Adam Rodriguez, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
You waive and abandon the remainders, Your Honor.
any objections?
Objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court would find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to revoke the defendant's community supervision, adjudicate him guilty, and sentence him to 5 years in the prison
That is an understanding, Your Honor.
and run concurrent with
Yes.
the case that we just pled on, Your Honor.
All right, probation, has he done anything on probation?
Only the top evaluation.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
James.
All right, why were you not successful on probation?
I was actually did my classes, AA and A. Had my probation officer submit copies. And I also was the day I got arrested for my new charges. I was gonna graduate my parenting class. So, I needed 2 payments. I just got a job 2 months prior to the arrest, and I did all the classes I had to. I was just about to graduate my parenting.
Well, parenting classes and AA meetings don't matter if you still end up breaking the law.
And
I guess when probation knocked on your door for a scheduled field visit, that was shocking, wasn't it? See, and you know what? People always wonder why field visits, because you know what? You really don't know if someone's doing well until you get a chance to see them in their homes or sit down and have a meal with them. All right, the court is going to follow your agreement. Are you waiving your right to appeal?
Yes.
The court is going to follow your agreement, find you guilty, revoke, sentence you to 5 years in the prison. This is run concurrent with 2025 CR 002041. There's to be no contact with David Rodriguez. And I'll suggest the therapeutic community. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, just one moment. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You need to start asking yourself what you want to do with the rest of your life, because what's going to end up happening is you're going to wake up and find that you spent the majority of your life in somebody's prison or jail. If you don't change, that's what's going to end up happening. If you continue on the path that you're on, people who sell drugs, one of two things going to end up happening. One, you may make some money, but at the end of the day, you're not going to know where it went. Or somebody's going to try to rob you to take your drugs and your money. Or somebody's going to be upset with you because you let somebody rob you and take the drugs and they want their money. Do you understand? Do better. Good luck to you. Oh, thank you. God bless you too.
Thank you, Your Honor. May I be excused?
Yes.
Thank you, Judge.
So finally, here is Ms. Revolo, who vanished from probation over a year and expect the court to understand her reasons. Let's see how the judge handles this.
All right, we're back on the record in 2020 CR 5583 State versus Erica and Arovala. Can I have parties re-announced, please?
Megan Gallagher for the state.
Lindsay Shaw for Mr. Revelo.
All right, Ms. Arevalo. You reviewed the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver controlled substance penalty group 1, 4 grams to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
Yes.
All right, state.
The state's gonna be pursuing on the motion to supplement the motion to introduce guilt to not accomplish.
Yes.
So violation of condition number 5 in Dare County, Texas, the defendant Erica Ann Arevalo, the defendant there failed to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 5.
How do you plead to that? True or not true?
And we'll wait and abandon it.
Any objection to the
No,
waivers?
Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 5 years or 99 years or life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? No. Do you still wish to plead true, knowing that I could send you to prison for life?
Yes.
All right, the court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not, state is asking for revocation, given the defendant's being true and in compliance with reporting on conditions of probation.
All right, in defense, what are you requesting?
Judge, if you look at the court summary, probation was recommending SATIF. And in this case, we are asking that the court consider something lesser than sending Ms. Arevalo to prison. We obviously, by pleading true, she understands that it was wrong to not report for over 2 years. But I would like to point out from January of 2021 until July of 2023, she did report. She was reporting. She did complete the outpatient treatment program, and she was holding down a full-time job. That job, which she still has, well, did have until she was arrested last month. She's a full-time cashier at a Shell gas station. It's the same job she had when she got this probation. And when she stopped reporting in July of 2023, and I'm going to have her speak to the court, but she sort of got tasked with helping take care of her disabled mother. She's also been helping her grandchild, or helping take care of her 5-year-old granddaughter who has so she's special needs. She has a feeding tube. There's a lot of issues going on. And so she put that above taking care of herself and doing what she was supposed to do by reporting to probation. She has no criminal history besides this felony case. She does not have any other felonies. She's never been on any other type of deferred adjudication. And she's never been to prison, obviously. So we're asking the court punish her by sending her to a treatment facility, but give her a second chance before she's gets a felony conviction and has to go to TDC. And if I would like to call Miss Arevalo.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Erica.
All right, you may proceed.
Hey, Erica, I want you to tell the judge, why should she give you this opportunity? Why should she not revoke you and continue you on probation? Can you tell the court?
You can give me a second chance. I'm more better out there of service out there in the world than I am in prison. Never been to prison. This is actually my first time ever being locked up this long. I'm actually I did a whole 180. That was in 2020. I work now. I am actually a grandmother. I still take care of my kids. I still, my son lives with me. I help my mother because she's disabled. My brother was her provider, but then he passed away like 3 months ago. So I've been having to help her, help my daughter with her special needs. She's blind and eats through a feeding tube, so I also have to help her. I'm a babysitter for my other daughter while I'm not working, so I'm don't want the felony on my record, because then it would be harder for me to get a job. So if you could just put a chance on me again, I'm actually a lot better out there than I am here. And I'm not even a criminal. I've never even,
No, I mean, you had drugs that you intended to deliver. They were in baggies. And what I can tell you is everybody in the box will tell me that they're better in the real world than being in prison. And one of your conditions of probation that you just testified to violating is that I ordered that you were not to have unsupervised contact with minors and you're babysitting. And the reason why I ordered that is because you have possession with intent to deliver drugs. And it was a lot of drugs.
without, I mean, that's not the reason why I totally dropped all that when my grandkids came up, because how am I gonna help them if I'm in prison? So that's
I
basically.
mean, all you had to do was report.
I mean, basically, I've been taking care of everybody else besides myself. And
So honestly, basically, you haven't been doing probation. You know, a lot of people feel as though when they're on probation, they're supposed to report and do certain things. Those are called their conditions. And they're just like, well, I know I didn't do anything on probation, but I didn't pick up any new offenses. I'm just out here living my life. If that's the case, then you're not really on probation because you're not reporting, you're not doing anything that you're supposed to do. You're just living your life. And when people come before me and they say, I know I haven't reported for over a year, which you haven't reported for over a year, but I didn't pick up any new cases. Do you know that is not really saying anything? Because there are a lot of people who are not on probation and who haven't picked up any new cases. That's like the bare minimum. Don't pick up any new cases. Don't, join a gang. So you haven't done anything on probation. What have you done?
I've been working and helping out my family and.
No, what have you done on probation?
Oh, I mean, I did that class and I was doing everything until I ended up having to move in with my mom, and then she ended up losing her housing. And I mean, I know life is like the dumbest, but actually I've been living life trying to better myself and do you know, if you could just give me, I've never even been to prison. Um, I'm sorry, I don't want this on my record, because then it's gonna be harder for me to even get a job when I do get, say you do send me. I mean, it's kind of gonna be even harder for me to. So if I could, please don't send me to prison. Not a prison person. Not,
I don't know anybody who's a prison person, really. But here's the thing, these are consequences to actions, right? So you're not reporting, there was a consequence to that. You could potentially end up being revoked. And I usually tell people, hey, if you think that some action you're going to take could potentially result in you going to prison, then don't do it. If you think it may happen, then don't do it. And you did it. You didn't report. Nobody's seen you for a year. Everything that you're telling me now, nobody's seen you for a year.
I've had a job for 2 years, so I wasn't on the run. I already started getting child support. Like, I already started getting my income tax.
No, I mean, I understand what you're saying, but you're on probation for possession with intent to deliver drugs. That means that you have drugs for selling and they were packaged for selling. And you were given deferred adjudication, 5 years deferred adjudication, and nobody's seen you.
Another little treatment or.
This is what the court is going to do. The court is going to find violation of condition number 5 true. The court is going to find you guilty. The court will revoke I'll take into consideration that the fact that she hasn't picked up any new offenses. And I'll sentence her to 5 years in the prison, give her credit for any time served, and request the therapeutic community. And there's to be no unsupervised contact with minors. And there's a $1,500 fine, time, and money to run concurrently. Let's see. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Using life hardship as an excuse to ghost probation seems wild, don't you think?